What was it that made the number in this post significant to you?
Well, I was looking for a number for Justin Cobb.
And what led you to believe that this number was a correct number for Justin Cobb?
Well, it was, there's probably more to it than just this, but it was posted in this Instagram comment and
Posted by the owner or user of the account?
That was false speculation. I'll object.
Yeah.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to?
I would renew my objection and also object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And,
Okay,
and Your Honor,
when we were up here at the bench,
so, Your Honor, I'll ask additional questions that I think will.
sustained.
Okay. So, after seeing this
Your Honor,
number.
I have a motion, please. May we step up?
Yeah. I'm going to excuse y'all to the jury room.
Well, this is getting serious now. She's sending the whole team out. Uh-oh. And we're not going to be able to hear it. Doggone it. Oh, actually we will, because she's sending the jury out. Yeah. So they don't actually have to come to the front. Okay. Sorry.
Your Honor, may we excuse the witness?
Yeah. Mr. Smirker, you can go ahead and step outside for us. Thank you.
Ooh, it's about to get hectic up in here. Let's go. Let's raise some voices. Let's go. Let's fuss a little bit. Let's hurt some feelings. Let's go.
Your Honor, so
Your
well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting, this is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up?
Come on. Let's get this done. Let's do the right thing. Come on.
yes. Would you put it up? First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with where's the phone number? There it is.
Yeah.
Okay.
The comments generally being all of the writing on the right side of the picture.
Your Honor.
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him
you?
what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked for. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is it?
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor.
Come on.
And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
phone number with the comments.
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally
And
asked
I
it.
asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being
Come
offered
on.
to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation.
That's not true.
Where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse.
I asked,
here. It is what it is. I think that the state was disingenuous about it. State's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now. So I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have time after time after time continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful. But honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented.
Come on.
I'm going to take a recess for a few minutes.
Yes.
I'll have a ruling when I get back.
Big screen. Big screen. She's so mad, y'all. Oh my gosh. Oh, please, everybody take a break. Go get your drinks. Please go get your popcorn. This right here is must-see TV. Oh my gosh. Yo, she said, yo, you done made me so mad. I was in the midst of typing. I just gave up. You done made me so mad. She said, I got to go. Big screen. Wow. Who had this on their bingo board today? I literally said this morning, it's not going to be that exciting. There's not going to be that much. Hey, Whitaker, editor Jason, rewind the tape to the part this morning before your coffee kicked in and you said, it's not going to really be that exciting today. There's not going to be a lot of fireworks. My goodness, in the morning. I don't think there's supposed to be any fireworks this week. I'll be honest with you. I don't believe there's anything, bombshell type of stuff. And I don't believe so. But we'll keep our eyes out for sure. Oh my gosh. I think she's going to, I'm not going to even use the word. I'm not going to use the word. I don't think mistrial is coming into the chat. But my goodness, in the morning, there's some cuss words being said. Hey. Wow. That's what we need. Shout out to Mr. Adams. Good night. We've never seen Judge Whitaker raise her voice. And if you paid attention, she's not giggling today. She came in on 10. I don't know if a tree fell down in her yard during the storm. I don't know if her HOA is charging her because her mailbox isn't right. I don't know. But something is not right with old Paige over there. And somebody done turned the page and Paige done come out the bag on them. That's for sure. Oh my gosh. Oh, this is a glorious, wonderful thing. I'm telling you right now, I cannot wait. Oh my gosh. Please come back quick. That woman said, I'm so tired of this. I got to go take a walk. She literally said, I might have to rewind that. Y'all, okay, I got to pull that back up. Okay. Y'all know that thing was funny. I don't care what y'all say. Y'all know that joint was hilarious. Oh, she looks ready to spit fire. Let's go.
I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse here. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented.
Come on.
I'm going to take a recess for a few minutes.
Yes.
I'll have a ruling when I get back.
Big screen. Big screen. She's so mad, y'all. Oh my gosh. Oh, please, everybody take a break. Go get your drinks. Please go get your. Oh my gosh, that is the best. Oh my gosh. I might make a video clip and play that like 10 times. She is so upset. Oh my gosh. Now, okay, here it is though. Here it is, Marlon Gibbs. You can't come back in here after you done took a couple drinks of some Grey Goose and got a call from Fonnie. You better come in here and raise Cain. I mean, I'm fine with mistrial. I'm fine with sanctions. I'm fine with throwing out all of this witness foolishness. Hey, but it has to be something that's notable. I want newspaper articles written about it. I want them to stop CNN and be like, Judge Whitaker jumped off the top rope and elbow slammed. I need some kind of evidence that she means business. If that not be the case, then I'm just going to go and take a nap. I'm telling y'all, I can tell some of y'all been praying. Clearly, y'all been praying for Judge Paige Whitaker, that she would get a clue, that she would get fed up, that she would have her, Stella got a groove back moment, wait and exhale moment. I don't know what it is, but y'all been praying because that woman we said it from the beginning. We said it at 8:30. She looked really upset. She was short. She was snarky, and we said it. But, oh, hey, they're back. Oh my gosh. Woo, she done.
All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to, I'm going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement. So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter
Go
before
ahead.
the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F second 255. It's the Ninth Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway, based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
Well, I don't know. I don't know what they think, but I will say this. This is not becoming in the state of Georgia of a trial. And it is all the time, Your Honor. It is all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding walls, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court, and I think that it does rise to a level now, but I understand what you rule, but I think that we're well beyond it. And the reason I said promote these things is it's literally from
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor, would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next question, please?
Yes, it's renewed.
Thank you.
the Harvey rule does apply.
Yes.
Wow, Adriane Love didn't say anything. She said nothing. Wow.
Yo, hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian.